in the Crown Court at Nottingham, Friday the 16th of September 2022. Regina versus Alex Belfield. Sentencing and remarks and judgment on the Crown's application under Section 5A of the Protection from Harassment Act 1997. The Honourable Mr Justice Saini's words. Mr Belfield, on the 5th of August 2022, following a 5-week trial here at Nottingham Crown Court, the jury convicted you on 4 counts. On count 5, you were convicted of stalking Mr Bernard Spedding, known professionally as Bernie Keefe. I will refer to him by that name. The stalking of Mr Keefe caused him serious alarm or distress. On count 5, you were convicted of stalking Ben Hughes, also causing him serious alarm or distress. On count 7, you were convicted of stalking Philip Dehaney. On count 8, you were convicted of stalking Jeremy Vine. On counts 5 and 6 are the more serious form of aggravated stalking because they caused your victims serious alarm or distress. On counts 7 and 8, reflect the less serious form of stalking under the law. It now falls to me to sentence you for these offences and to deal with the Crown's related application for restraining orders against you in relation to Mr Keefe, Mr Hughes, Mr Dehaney and Mr Vine. The orders seek to prevent further harassment of these people. I will refer to these individuals collectively in my remarks as the complainants. At the end of my sentencing, I will also need to deal with a separate matter, which is the Crown's application for restraining orders against you in relation to the 4 complainants where the jury acquitted you. Those were counts 1 to 4 concerning Rosina Breen, Helen Thomas, Liz Green, and Stephanie Hurst. I will deliver a judgment on that application when I conclude my sentencing, and it will be available as an addendum to the sentencing remarks I am now delivering. The applications for restraining orders are not opposed by you, but I need to give my reasonings for making them. My attention has been helpfully drawn by counsel to the intimidatory offences guideline. I have also considered the general guideline on custodial sentences and the totality guideline, as well as the material provisions of the Sentencing Act 2020. Given that there were separate crimes against separate victims, which I consider need to be each marked with distinct sentences, I propose to pass sentences which will be served consecutively. I am aware that the certain of the facts overlap, but consider nevertheless that this is a case for consecutive sentences given the particular forms your harassment of different victims took. Your offences are so serious that not only a custodial sentence can be justified, but because I am sentencing you for more than one offence, I must ensure that, standing back, the total overall sentence reflects all of your offending behaviour in a just and proportionate manner. That is the principle of the totality to which I will make reference in my remarks and which you have heard counsel discussing with me. I will now apply that principle by adjusting each individual consecutive sentence. I have received very helpful oral and written submissions from Mr. McGuinness, KC, and Mr. Rowcliffe for the Crown, and from Mr. Aubrey, KC, for you. Mr. Aubrey, KC, presented your mitigation in a measured and realistic manner, recognising that the custody threshold had been crossed. I am grateful to him and to Mr. McGuinness, KC, and Mr. Rowcliffe for the substantial assistance they provided to me throughout the trial. I have had regard to the moving victim personal statements which have been submitted to the court. I emphasize, however, that the issue of the appropriate sentences is for me and not for your victims to decide, applying the relevant guidelines and the law. A very helpful and detailed pre-sentence report is before me. That report shows that you have finally acknowledged the distress caused to your victims, but highlights that you still appear to focus on the impact of events on you and feel in certain respects that you have been unjustly treated. I have read the several character references provided for you. I accept they speak in positive terms about you and commend your work in the community. Mr. Aubrey KC has reminded me of your successful career and online following and underlined your online following and underlined your particular style and broadcast persona. It is also clear that you come from a close family and that you have acted with real kindness in the assistance those facing substantial challenges in their lives, particularly during the pandemic. It was also submitted that custody would have a profound effect on you and those dependent upon you, including 9 employees. Where I state findings of fact in my sentencing remarks, I am satisfied of those facts on the evidence called before the jury to stand, which makes me sure of them. A different civil standard applies when I deal with the Crown's applications for restraining orders. I will begin with some of the common features of the conduct on the basis of which you were convicted by the jury, and I will then turn to the specific victims. The stalking you committed was not conventional type, which is popularized in the press. You did not meet or physically approach or watch any of your victims as a traditional stalker might have done. Your methods were, however, just as effective as a way of intimidating your victims and were in many ways much harder to deal with. Your stalking consisted of use of repeated emails, communications, social media content on Twitter, and the creation and publication of YouTube videos on your channel, The Voice of Reason, in which you commented in highly negative and often abusive terms about the complainants. As you described in some of your videos, your aim was to haunt your victims. They gave graphic evidence that they believed you would be true to your word and would never go away. It was only the imposition of bail conditions restraining your actions which gave them peace of mind to the trial. A number of witnesses said you had weaponized the internet. I find that to be wholly apt description of your conduct. The emails were very widely distributed and not simply sent directly to victims. When the victims sought to block your emails, the common device you used was a different email address to get through to them. That tactic was used by you on many occasions. In some instances, you used the technique of identifying the personal home addresses of individuals in your communications, which understandably caused them to fear for their safety. Their feelings of in effect being followed or monitored were justified. The YouTube videos and tweets reached your very substantial audience. The effect of these communications was to encourage the readers and viewers to form highly negative views of the complainants, often based on wholly false allegations by you. Those readers and viewers then join the abuse of the complainants in a way which is sadly now familiar feature of social media interaction. Online stalkers like you have the ability to recruit an army of followers whose conduct massively expands the effect of your stalking. That is why I say your stalking is in many respects more serious than the conventional stalker. I accept that in certain limited respects, you were acting as a form of media commentator in stating views on matters of public interest when you made some of your communications. However, even accepting the latitude of our laws, give to those exercising free speech rights on the jury's verdicts, you exceeded the generous margins. You made communications which had serious impacts on the private lives of the complainants, with distressing effects on their mental and physical health. I find that the motivating factor in your communications about these complainants was not to exercise of journalistic freedom to comment on matters of public interest, but personal grudges and responses to real and apparent slights. I am not imposing sentences on you because you made comments about the BBC or about matters of public interest. Your sentences reflect your repeated and personal harassment of the victims and not your views on any issue of public interest. You are entitled to hold and express views, but you are not entitled to destroy the personal lives of your victims through online harassment. I now turn to the specific counts. I have taken into account all of the oral and written evidence at the trial, but in the interests of brevity, will only summarise the nature of your conduct towards each victim at a high level in order to explain my sentences and application of the guidelines. Count 4, Bernard Spedding, known as Bernie Keefe. Turning first to count 4 concerning Bernie Keefe, he is a highly respected and established presenter of many years, standing at the BBC Radio Northampton. Your harassment of him took place over a substantial period of time. There were 9 years between 2011 and 2020. It was only at the very end of this period that the harassment overlapped to some extent with that of your other complainants. Having once been a friend of the acquaintance, your campaign of harassment against Mr. Keefe first took the form of many emails which sought to criticise any aspect of his shows and then moved into highly offensive material. He did his best to ignore your communications and he asked you in a polite and restrained terms to stop. You did not. There were many communications and not all were produced in court. They appear to have become less frequent around 2018, but your communications escalated substantially from the 1st of October 2019, when you suspected that Mr. Keefe had communicated by email with a person he did not know, Mr. Hughes, to warn him of your past behaviour and to inform him of what he believed you had done to other BBC employees. Mr. Hughes then published part of that email from Mr. Keefe in a tweet. You then bombarded Mr. Keefe with Facebook messages, emails, and made highly abusive YouTube videos about him, including false allegations that he had mental health issues. Even when he instructed lawyers for you to communicate with, and they requested you not to contact Mr. Keefe, you continued to send repeated abusive communications directly to Mr. Keefe. He had no escape from you. There was no purpose in communicating directly other than continuing your campaign of harassment. Mr. Keefe gave the jury graphic and distressing evidence of how close he came to hanging himself. He was seconds away from taking his own life as a result of your conduct. You made this highly successful and confident radio presenter lose all joy in life and turned him into a shell. Mr. Keefe also felt at a serious physical risk of attack, although at no point did you commit any physical acts against him. Mr. Keefe gave evidence, which I accept, of heightened awareness of individuals, additional security measures, and said he gave his fellow villagers copies of your photograph. He was terrified of you. I find that count 5 falls within category A1 of the relevant stalking guidelines. That is the most serious category. As As to culpability, the history I have summarized demonstrates that your actions were conducted over a sustained period, and I find you were intended to maximize Mr. Keith's distress. Your actions were an extreme nature and push this matter clearly into the top of the culpability range. As to harm, as I have identified, very significant stress was caused to Mr. Keith. I need to identify the starting point for your sentence. Your stalking of Mr. Keith, as charged on the indictment, began before the 3rd of April 2017, the date when the maximum penalty was increased from 5 years to 10 years. The guideline reflects this higher penalty. It is common ground that the maximum penalty for this count is 5 years imprisonment. If your offending had been post 3rd of April 2017, the starting point under the guideline for this form of stalking would have been 5 years. Both the Crown and your counsel submitted, and I accept that I should move down from that starting point to take into account the lower, earlier statutory maximum of 5 years imprisonment. I will take a starting point of 2 years and 6 months. I then need to consider aggravating and mitigating factors. There are the following 2 matters which I have not already taken into account in my first categorization. They justify upward movement from the starting point. First, the fact that your postings publicly about Mr. Keith resulted in followers of your social media profiles abusing him over a lengthy period. In some cases, this has extended to death threats. Second, the false and scandalous accusation that Mr. Keith had regularly had sex in public on gay beaches with strangers for decades, coupled with the threat to include the allegation in the story which you would sell for publication. The mitigation is lack of previous convictions and previous good character. There has also been some remorse expressed as recorded in the pre-sentencing report. I make allowance for these matters, and I also have regard to the principle of totality in making an adjustment to my sentence. Having regard to all these matters, I impose a sentence of imprisonment of 2 years and 6 months in respect of count 5 concerning Mr. Count 6, Ben Hughes. As to count 6 concerning Mr. Hughes, he is a videographer who works in the theatre and wedding industry. You did not know him and have in fact never met him. His problems began when he went online in late 2019 to support those in the theatre who believed were being unfairly attacked by you on Twitter. Your stalking of him took place between the end of 2019 and went into 2020 when the police became involved. Your attacks on Mr. Hughes took the form of both personal emails as well as highly distressing YouTube videos. You felt that Mr. Hughes had libeled you by a post on Twitter, which included part of the private email Mr. Keith had sent to Mr. Hughes on the 1st of October 2019. I've already referred to that email. I am sure Mr. Hughes will regret for the rest of his life that he included that email in his tweet. That is because it led you to direct a flood of abuse towards him, despite a rapid apology and retraction from him. You claimed in multiple communications to have hired and paid lawyers to sue Mr. Hughes. Those statements were false. This was intimidatory behaviour towards a man who felt his family and home were at risk. I find you had no intention of taking legal action, but decided to use online threats as a way to obtain details of who had supplied Mr. Hughes with the information about you, which he published in his tweet. Mr. Hughes gave compelling evidence as to the distress he suffered and his wish to keep his pregnant wife out of the dispute. The statutory maximum for this offence is 10 years. I find that this stalking was category B1 within the guideline. As to culpability, I find your actions were intended to maximise distress to Mr. Hughes and took place over a sustained period, albeit a period shorter than in the case of Mr. Keith. As to harm, it is clear that serious distress was caused to Mr. Hughes, and he has had to seek professional help as a result of your offending. The category B1 starting point is 2 years and 6 months imprisonment with a range of 1 to 4 years. As to the aggravating factors justifying upward adjustment, there are 4 factors increasing seriousness and which I have not already taken into account in my categorization. First, you involved Mr. Hughes' family by using in your videos pictures of his wife and young child. You attached an image of a fetal scan to an email and attempted to contact his wife. Secondly, you contacted Mr. Hughes' clients intending to undermine his business. Thirdly, you encouraged your followers to contact him, and your posting publicly about Mr. Hughes resulted in followers of your social media profiles abusing Mr. Hughes. Fourthly, Google searches continue to reference articles about Mr. Hughes which remain available on your websites, thereby not only perpetuating the distress but also the financial effects on Mr. Hughes. These matters justify upward movement from the starting point. As to downward adjustment, the mitigation is lack of previous convictions, good character and remorse in the form I have stated. These matters justify some limited downward movement, and I will also need to adjust the sentence to take into account the principle of totality. Having regard to all of these matters in respect of count 5 concerning Mr. Hughes, I impose a sentence of 2 years and 6 months imprisonment to run consecutively on the sentence of count 5. Count 7, Philip Dehaney. As to count 7 concerning Mr. Dehaney, the jury acquitted you of a more serious form of stalking, but found you guilty of the lesser alternative of the basic stalking offence. I must respect the jury's acquittal on the more serious charge, and it is of relevance when I consider the levels of harm caused. Like Mr. Hughes, Mr. Dehaney was the subject of a vicious and continued campaign of abuse, principally by way of YouTube videos. He was a theatre critic and blogger who did not wish to be tagged by you into what he regarded as offensive tweets about those in the industry. He had never met you. He asked that you cease. Your online attacks and emails began in the early new year of 2020. You wrongly believed, I apologize, that he had repeated the contents of the Hughes tweet. You again made false representations as to intended legal action. This victim started a blog in which he provided a day-to-day account of your abusive conduct. That inflamed you further. When Mr. Dehaney became uncontactable and refused to engage with you, you went as far as calling his mother during the lockdown at the family home. We heard a recording of that call. She is clearly a robust and impressive person. Everyone needs a mum like her. Mr. Dehaney's mother repeatedly and fairly asked you again and again what had her son done that was wrong. You failed to provide any answer. The call was, in my judgment, part of the harassment of her son, who stood by her while she took this call. It was an outrageous and cruel act to call her and to make a recording. Not only did you record the conversation, you then made false and misleading comments about what she had said about her son, seeking to demean him in a public forum. Getting his parents involved caused serious and continuing fractures in Mr. Dehaney's relationship with them, and in particular with his father. You also sought to humiliate Mr. Dehaney about his mental health in your postings and videos. Further, you sought to, in effect, blackmail him by revealing details of a long spent conviction. The content of the YouTube videos you made about him at the time when he was clearly vulnerable and shielding with his parents during the first lockdown was shocking. The statutory maximum for this offence is 6 months. I have to, however, consider the guideline. I find that this offence falls within category A1 of the relevant stalking guideline. That is the highest category. As to culpability, your actions were planned, repetitive, and intended to cause Mr. Dehaney distress and included hostility based on his sexual means. You cannot have, his sexual orientation. I do not consider the fact that you are a member of the LGBTQ plus community means you cannot have acted with hostility based on Mr. Dehaney's sexual orientation. As to harm, having regard to the jury's verdicts, including the acquittal, I find harm and distress, including psychological harm, were caused to Mr. Dehaney. Mr. Dehaney has been unable to continue his blogging enterprise as a result of your actions. This was a significant change in lifestyle. The category A1 point is 12 weeks custody with a range of a high-level community order to 26 weeks custody. As to aggravating factors, increasing seriousness and justifying upward movement, there is one matter which I have not already taken into account. It is the fact that you posted publicly about him and that resulted in followers on your social media profiles abusing Mr. Dehaney. That magnified the effect of your abuse. These matters push the offence up in the category range. As to the downward adjustment, the mitigation is lack of previous convictions, good character, and some remorse in the form I've stated. I also have to have regard to the principle of totality and have adjusted my sentence. I impose a sentence of imprisonment of 13 weeks for count 7 to run consecutively to the sentence on count 6. Count 8, Jeremy Vine. I turn to count 8 concerning Mr. Vine, who is a well-known radio and TV presenter. The jury acquitted you of the more serious form of stalking, but found you guilty of a lesser alternative of basic stalking. Until trial, you had not met Mr. Vine. Your actions against Mr. Vine consisted of highly abusive and wholly false allegations given mass Twitter and video exposure. These were allegations to the effect that Mr. Vine had somehow stolen £1,000 of BBC licence payers' money, funds, to use for what you called a piss-up or party following the memorial service of a dear friend of Mr. Vine, Mr. John Myers. Mr. Myers was a prominent personality in the radio industry, and the BBC made a modest contribution to his memorial fund. Mr. Vine did not know about this at the material time, and the BBC contribution had absolutely nothing to do with him. Mr. Vine did not steal anything, nor did the BBC pay for the so-called piss-up. The allegations you made against Mr. Vine were wholly false. You boasted online about the fact that in excess of 400,000 people had viewed your video about Mr. Vine containing these false allegations. Your assertions in your videos and tweets that your allegations were supported by BBC answers to freedom of information requests was also wholly false. They provided no support, as was revealed at trial. You were not a whistleblower in any sense, but developed a fixation with pursuing Mr. Vine with a campaign of abuse. The effect of your conduct on Mr. Vine's family and daughters was significant. Although you at no stage committed any physical acts, Mr. Vine considered himself and his family to be at risk from you and your followers. He had to ask his family to watch out for you and take care in and around their home address. You published his home address to a mass audience. The statutory maximum for this offence against Mr. Vine is 6 months imprisonment, but I have to again return to the guideline. I find that this stalking of Mr. Vine falls under category A1 of the stalking guideline, the highest category. As to culpability, your false allegations were given wide publicity over 2 months and were intended to maximise Mr. Vine's distress. As to harm, I recognise the need to give weight to the jury's verdicts, including the acquittal. I find harm and distress, including psychological harm, was caused to Mr. Vine. He also had to make precautionary lifestyle changes for himself and his family. The category A1 starting point is 12 weeks custody with a range of a high-level community order to 26 weeks custody. As to aggravating factors, which I have not already taken into account in categorization, there are 2 matters. First, you actively encouraged others to contact Mr. Vine during his broadcasts to pursue the baseless allegation of theft of public money. Secondly, you also encouraged others to provide private information about Mr. Vine's family and friends. Your false allegations against Mr. Vine led to a torrent of abuse being suffered online by Mr. Vine. That went into many thousands of abusive tweets received by him and personal threats. I consider that these aggravating matters take this offence up in the category range. As to the downward adjustment, the mitigation is the lack of previous convictions, good character, and remorse in the form I have stated. I also have to have regard to the principle of totality in adjusting the sentence. For the count 8 concerning Mr. Vine, I impose a sentence of 13 weeks to run consecutively to the sentence on count 7. Summary of sentences. I will now sentences. For count 5 concerning Mr. Keith, 2 years, 6 months imprisonment. For count 6 concerning Mr. Hughes, 2 years, 6 months imprisonment, to be served consecutively to count 5. For count 7 concerning Mr. Dehaney, 13 weeks imprisonment, to be served consecutively to count 6. For count 8 concerning Mr. Vine, 13 weeks imprisonment to be served consecutively to count 7. This amounts to a total of 5 years and 26 weeks imprisonment. This is the shortest sentence commensurate with the seriousness of your offence and application of the principle of totality. You will serve up to 1/2 of this sentence in custody. You will serve the remainder on licence. You must keep to the terms of your licence and commit no further offence, or you will be liable to be recalled, and you may then serve the rest of your sentence in custody. I now turn to the issue of the restraining orders in the cases where you were convicted of stalking these 4 complainants. You do not oppose those orders, but I need to give my reasoning for making them independently of your non-opposition. Restraining orders under Section 360 of the Sentencing Act 2020. Based on the jury's verdicts in relation to each of these complainants and my assessment that absent a restraint, you will repeat the stalking and harassment, I am satisfied that restraining orders on an indefinite basis are necessary. Your past conduct and qualified expression of remorse establish that the court's intervention is necessary to protect these complainants. The terms of the draft orders before me are appropriately tailored to ensure that they only interfere with your freedom of speech rights to a limited and proportionate level. I accordingly make orders in terms of the orders before me restraining you under Section 360 of the Sentencing Act 2020 as regards to each of Bernard Spedding, Ben Hughes, Philip Dehaney, and Jeremy Vine. You are, until further ordered, prohibited from contacting or attempting to contact them by any means, whether direct or indirect. You must not publish through any form of publication or electronic communication any statement or any other material relating to or purporting to relate to them. You must not monitor the use of any of them on the internet, email, or any other form of electronic communication. Any breach of those orders is a serious criminal offence with substantial criminal penalties, which may include imprisonment of up to 5 years. You will be given a written record of the terms of the orders. If for any reason the orders are no longer necessary and appropriate, then either you or the complainants may apply to have the court for them to be amended or removed. But until that time, which may never come, they will remain in force and must be complied with to the letter. Prosecution costs. The costs incurred by the Crown in respect of the proceedings are £27,990, and it makes an application for such costs. I am satisfied that you should be made to pay a part of these costs pursuant to Section 18(1) of the Prosecution of Offences Act 1985. I have taken into account the point made on your behalf about the acquittals and convictions on lesser counts and other penalties I have imposed. I consider a fair and proportionate sum to be £10,000. Based on the ownership of a house, albeit mortgaged, and the income I infer you have received from your YouTube channel, and in the absence of other counter evidence, I am satisfied you have the means and to meet the cost of £10,000. Indeed, it has not been submitted that you do not have the means to pay this sum. The surcharge will apply. Finally, I turn to my judgment on the Crown's application for restraining orders in relation to the complainants where the jury acquitted you. Again, you do not oppose that application, but I need to be satisfied that it is appropriate for me to make the orders and to give the reasons for my decision.